Hello, everyone. My name is Elisa, and together with Valeriana and Emma, I want to thank all of you for joining us today to discuss the intergenerational dimension of human rights and public interest litigation aimed at protecting children, youth, and future generations' rights. This webinar is a joint initiative between the Early Career Specialist Group of the World Commission on Environmental Law and the Youth and Environment Europe. As Emma will introduce the work of Youth and Environment Europe later on, I would like to invite Ayman Sharkayu, Deputy Chair of the IUCN World Commission on Environmental Law, to say a few words about the Commission and welcome our speakers and our participants.
Hello, everyone. This is Ayman Sharkayu, Deputy Chair of the IUCN WCEL speaking. I'm very happy to be part of this important webinar. So briefly, I'd like to introduce the Commission. So the IUCN World Commission on Environmental Law is one of the 7 commissions of the International Union for the Conservation of Nature. It promotes the environmental rule of law globally, particularly in countries that seek to improve the law and governance system. It aims to strengthen the capacity of governments, the judiciary, prosecutors, law schools, and other stakeholders as they develop and implement environmental law. We have about 1,000 members all over the world. We also have 8 specialist groups that are looking at different topics, such as biodiversity law, climate change law. Very happy to have an earlier career specialist group that, of course, is co-led by Marina and Alvin, and that has taken an important role in co-organizing today's event. They're one of the most active specialist groups we have, and we're indeed very proud of their important work. Also on oceans, peace, security, and conflict, soil and sustainable agriculture, water, and wetlands. We also have 4 task forces. Now, the difference when it comes to task forces as opposed to specialist groups is that task forces are a bit more focused in what they look at. For example, we have one on the model forest law, one on the agreement on plastic pollution, one on the Global Judicial Institute on the Environment, and one on the right of nature. So that's it regarding the Commission. Regarding the very important topic of today, I just wanted to briefly say and highlight the importance of the Summit of the Future that will be taking place next year. I just got back yesterday from New York, where, as you know, UNGA is taking place. And tomorrow, there will be a ministerial meeting where they will be discussing the modalities of the Summit of the Future. Marina and I are part of a task force that is looking with other organizations at the potential declaration on future generations and how we define, for example, future generation as complementary and opposite of youth, of course. So having said that, I wish you all a very successful event. And again, I express my appreciation to the specialist group and also Youth and Environment Europe for organizing this particular event. Thank you very much.
Thank you, Ayman, very much for your words. Well, within the World Commission on Environmental Law, the Early Career Specialist Group provides a platform for early and mid-career professionals, including lawyers, practitioners, and researchers, and we look at different areas of progressive development of environmental law. In this context, Valeriana and I lead a project which is focused on international environmental law research, and if you want to know more about it, if you want to engage, please feel free to contact us. We'll put our emails in the chat box now. Well, before introducing the speakers of the first panel, I would like to say some words about the background of this webinar. We are promoting this debate because climate change disproportionately threatens the rights of children and adolescents and puts at risk the possibility of future generations to live in a safe world. Considering that they are at the beginning of their lives, these groups will still have to deal with extreme climate scenarios to which they had little or no contribution. Right now, every child in the world is exposed to at least one climate and environmental hazard. Those who are part of other vulnerable groups, such as people with disabilities, migrants, the poor, and indigenous peoples, especially girls, are even more at risk. This is reflecting in climate change litigation all over the world, since these groups are using the courts to defend their interests and try to enforce their rights. In this sense, the intergenerational perspective in climate litigation has established itself as a global trend and strategy for the protagonism and affirmation of the rights of children and young people in discussions about the climate. Given this background, now I give the floor to Valeriana, who will introduce our speakers and explain a bit more about the first panel. Thank you all.
Thank you, Elisa. So with that in mind, we divided this webinar into two sections. The first one will discuss the background on the intergenerational dimension of human rights. And for that, we will count on the experience of Dr. Aoife Nolan, who will discuss child rights consistent strategic litigation practice and how children's rights and future generations' rights are litigated. Dr. Carolina Medeiros Rocha Frasson, who will address the impacts of climate change on the human rights of young generations in Latin America. Dr. Hongenzai Fambasai, who will present a critical legal perspective on the interface of children's rights and climate change law. And Tabita Mbucha, who will share her perspective on the intergenerational aspects of human rights and climate justice as a young human rights advocate. The second panel will discuss public interest litigation driven by young generations, and Emma will later introduce our guest speakers for that part. Now, just a brief introduction for our first speakers. Dr. Nolan is a professor of international human rights law at the University of Nottingham and co-director of the Human Rights Law Center. She's also president of the Council of Europe's European Committee of Social Rights. Dr. Frasson is a specialist in climate and environmental justice. She holds a PhD from the University of São Paulo and is currently the climate manager at the World Resources Institute in Brazil. Dr. Fambasai is a specialist in child protection. He's a doctoral researcher at the Northwest University and is currently serving as an independent external expert in the Working Group on Children's Rights and Climate Change of the African Committee of Experts on the Rights and Welfare of the Child. Finally, Tabita Mbucha is a young lawyer from Kenya. She is a human rights advocate as well as an environmental conservationist. She is currently the human rights focal point for the Chemical and Waste Youth Platform and the National Youth Focal Point for Stop Ecocide International. So now, to start the first panel, I'll give the floor to Dr. Nolan. Over to you.
Thank you so much, Valeriana, and to all the organizers of this event. It's a real pleasure and it's a real privilege to be part of it. I need to start by saying that while I'm on the European Committee of Social Rights, which is a regional human rights monitoring body, none of what I say today has anything to do with that role. And I have to say that because actually, when you look at our mandate, it's very clear that a complaint could be brought to us on these issues. And so anything I say, totally independent, nothing to do with that. And today what I'm going to do is I'm going to speak to you a little bit about work that's been done in particular around the litigation of children's rights and future generations' rights globally. And in doing so, I'm going to focus in particular, if I can get my slides up, and that's always a challenge. Can you see them? Oh dear.
Yes.
Excellent. Sorry, it's completely possible that you wouldn't. So today what I want to talk to you about a little bit is this idea of putting children's rights at the heart of the intergenerational climate justice strategic litigation. And when I say strategic litigation, I'm pretty confident that it's the same thing that the organizers mean in terms of public interest litigation. You've lots of different terms, and essentially what it is, it's litigation that's trying to bring about positive change in the context of climate change. And I think that's probably what we're all talking about today to some degree. So I'm going to start by setting the scene a little bit. And I just want to start focusing because I'm a children's rights lawyer by background. So for me, the climate justice has been very interesting because I've come at it as someone who's worked in children's rights for years, and this is a new area, rather than someone who's come at children's rights from the perspective of having worked in the environment for many years. Okay, and it may be that and I think that brings a very specific perspective. So what are we seeing in climate justice strategic litigation from a child perspective? Well, first of all, it's very clear, and I'm sure this is why part of the reason we're having this event, is that we've seen this huge increase in climate justice cases being brought or on behalf of children using child rights argumentation. And I put academic citations in the slides and references there, and I've tried to use open access stuff just in case people want to look it up later. And, you know, in a way, this isn't surprising. We're seeing human rights argued much more in climate change litigation. We've heard reference to this idea of a rights turn, that, you know, that we're using rights in litigation to try to tackle climate change. And what we're seeing in particular is, while we see some cases involving children and focused on children's rights, we also see child rights being taken as part of more wide-ranging argumentation, okay? So children's rights being part of the arguments, not the only arguments being made. And I mean, there's a range of reasons why we're seeing this, right? And first of all, there's absolutely, and we heard Elisa already speak about it, the particular issues that children, and by that I mean people under 18, the particular issues they face as a group now and in future. And of course, Elisa's absolutely right when she says not all children, indeed not all humans, are affected similarly by climate change. And I'll come back to that later on. There's other reasons why lawyers are looking to children's rights in this context. Frankly, child rights specific protections give scope for new argumentation that isn't available when you look at the rights of other groups. And that's very, very important, both at the national and the international level. I think we also need to think quite carefully. It's not just about legal argumentation. There's no question that those bringing cases, including, of course, children and young people involved in such litigation, are aware of the fact that a view of children as the main actors in a case or strongly associated with a case, it increases media attention and focuses political attention as a result of the public sympathy and the support that children kind of generate as a social group, okay? And we have certainly seen a shift in the way in which media and politicians have spoken about climate change since we've seen movements like Fridays for Future and the work of groups such as those joining us today. And finally, the key, and for me, probably the most important reason, the most valuable reason we're seeing this litigation is we're seeing children themselves with, you know, also slightly older people pushing litigation as a way of advancing their own agendas, their own concerns around climate change. The other thing, however, that we need to be aware of is that we're seeing children's rights, they're not just being litigated by themselves, but they're also being litigated in the context as a hook for future generations and rights and interests, okay? And why are we seeing this happen? Well, obviously, there are significant common or mutual interests between children and future generations in the environmental protection context. And that means that, for instance, you see people arguing that actually children should have standing because of those shared interests, or because children are the most appropriate or the only possible representatives of future generations. Children sometimes qualify as future generations if you look at, say, constitutional protections, and vitally, child claimants in the here and now. And again, this isn't just about legal argumentation, it's about the way you characterize or shape a case. If you have children, living children, they provide a face for future generations. And future generations, it's very abstract, potentially, it's very theoretical. So if you have real life children, you have a face, you make that case real, and you make the rights impacts real. You also have a situation, and I don't know if we'll come back to this, but there is real concern around the notion of future generations' rights, that they could be used to constrain or limit the reproductive rights of women, for instance, the right to be born. And if you have living children, as opposed to unborn future generations, you avoid that issue. And Donger has made that point. And again, the other reason we see it happening, this future generations link, is because children themselves are pushing it. And I think it was really striking if you looked at the draft general comment, the first draft of the general comment, which was subsequently revised, the recent Committee on the Rights of the Child general comment on children's rights in the environment. They referred to the fact that children consistently, when they were, 16,000 children engaged with the committee, directly and indirectly, and a consistent, repeated theme was we speak for future generations. We want to speak for future generations. But I want us to think a little bit about the fact that, so we're seeing more and more of this litigation being brought, but the fact is it's not, and that is definitely good news in terms of the focus is on children. But I think what's interesting is when we look at how litigation and climate justice litigation has been carried out, when we consider the role that children's rights play in that litigation, it's outward facing. right? So where you have lawyers or others involved in planning or operationalizing strategic litigation, they think of children's rights as something for external decision makers. They're trying to get children's rights taken on board by policymakers or states or business or whatever, but they're not looking inwards. And the project that I ran for 3 years, and some of this presentation draws on that, we were concerned about using children's rights not just as something for other people by litigators, but something for litigators to put at the heart of their practice to make sure that their practice was child rights consistent. And we feel very strongly, and we argue, that if you need to do this, because otherwise if you have litigation that isn't child rights consistent, where children's rights are ignored, it really raises question about the legitimacy of that litigation. And it also, leaving aside the legitimacy, it also really affects the internal coherence and the ability of that litigation to actively advance children's rights enjoyment in practice. Okay, so there's kind of the legitimacy argument and the pragmatist argument. But either way, it's about children's rights not just being for the people that are the targets of litigation. And when we looked at litigator practice, we saw that climate justice was a site of both opportunity and risk for child rights consistent strategic litigation. Okay, and so what was some of the what were the challenges? Well, first of all, lots of people bringing climate justice litigation, lawyers, are not human rights specialists. And even if they are human rights specialists, they're often not child rights specialists. And it's a very specialized, developed area of law. The other thing is we found that many climate justice litigators aren't necessarily people who are used to working with children. They're not like people who've done years of child justice or child protection, who've thought very carefully about how they engage with, practice, and support children that they're working with in litigation. And that's a gap, and a gap that needs to be addressed. Another challenge is the highly technical nature of climate justice litigation argumentation. Now, there is no question, there are excellent examples, and Aurora is one of them, and I think Douglas will speak of it later, where you have young people with experience in law actively contributing to legal argumentation around climate justice. But that is the exception. It is not the norm in terms of what we have found. And a lot of that is to do with the fact that litigation and legal argumentation is quite technical. And so often when you're dealing with children or young people, they don't have law degrees, and lawyers love jargon, and we love being in control. And so we're not good at opening up that space or demystifying. And that, of course, reflects another point, which is that you have this power differential. You have this, if you have children and lawyers, it's ultimately adults and children. And that creates a power differential. In the same way, the adult-child power differential permeates all adult-child relationships, but it's particularly exacerbated where lawyers, for instance, are white, elite, male, global north-based, all these things, the global north-based dealing with global south, issues of concern to children in the global south, all of these are issues that exacerbate that power. You also have a problem where, and part of this is to do with inexperience in working with children, there's not an understanding that children's rights should shape litigator practice. And I think one of the ways in which I really see, and I find myself frustrated by some of the way that, all of this work is very good faith, but one of the things that I think is really interesting is there's a tendency to talk about any litigation that involves children and youth as being child-led or youth-led. But if you in fact look at cases, and again, there's numerous exceptions to this, I'm just going to talk about Aurora because there's someone here from this today, but in most of these cases, they aren't cases that are initiated and managed by children. It's often lawyers or others who are looking for clients, who reach out, who connect with child rights movements, but it's not children themselves leading the case or initiating the case. And it's not that that makes those cases any less valuable, but why are we calling them child-led? Because that's ultimately very disempowering. We wouldn't say something was led by women if women weren't actually leading it, if they weren't actually controlling it. But there's good stuff too. We see very impressive evidence, interest in upskilling on the part of litigators, climate justice litigation and those carrying it out, really a huge increase in the quality of work that's being done around this and the, taking children's rights into account. You also have brilliant child and youth movements, which frankly make it impossible for children not to be the drivers and true collaborators in litigation. And we're seeing more and more of that. I won't speak about that because I want to leave that open to the second panel. And also, frankly, there's funding to build capacity. So if litigators want to do this work and want to upskill in the child rights section, there's funding at the moment. So, but what do I mean by children's rights framework? So let me give you an example of what I mean, how children's rights would matter. So let's think about client selection. Okay, and let's think about the right to non-discrimination. Now, Elisa has already spoken about how some children are disproportionately affected by climate change, Indigenous, rural girls. But when we look at climate change litigation and you talk to litigators, they are honest and also very self-critical about the fact that often one goes for the clients that are easiest to engage with or easiest to find or easiest to get legal paperwork processed by. And that can lead to a bias towards elite urban children who are less at risk of climate change harms. And that does make, you do have to ask there, well, in fact, is that discriminating? Is the choice to go with those clients a discrimination against other children who are in greater need of litigation on their behalf? Another example might be the right to information. One of the things that is crucially important, and also this notion of the right of children to express their views and the right to freedom of expression. One of the things I've talked about, the adult-child power differential. It's absolutely fundamental that if children, and indeed anyone, is going to engage with litigation, that they understand both what's happening, what the prospects of success are, but also what the risks are. Okay, and they need to be consulted, and their views have to shape decisions made in the litigation. And that's very challenging for lawyers, but it's absolutely fundamental. And children have to be entitled to say, well, actually, based on the information you've given me, I want to withdraw. I think we'll stop now. And again, that can be challenging if you're halfway through litigation. I'm going to give one last example. Article 6, this right to survival and development. And these are all rights, sorry, I should have said under the UNCRC. There's a risk of reprisals in climate justice cases. And if you're a litigator, it is crucial that you do what is necessary to ensure that children who are involved in this litigation are protected from reprisals. Another example could be where you have a situation in which children are very actively involved in social media and are the face of the campaign. And we had interviews with children who spoke very clearly about the risks potentially presented by going onto social media. They didn't regret doing it, but they found the comments, they found the very negative response really undermining and terribly upsetting. And there is a need to think about how litigators and those working with litigators can support children to make sure they're protected to the greatest extent possible from things that would affect them in terms of their right, survival and development, or their right to protection from, from exploitation. So those are a few examples, and I'm conscious that, we need to finish. They apply. I've given you links here to publications that deal directly with all these different stages of litigation: planning, scoping, planning and design, operationalization, follow-up, and crucially, extra-legal advocacy and media work. And I'm not saying much about the fourth point, though I would do normally, because I'm very conscious our second panel, frankly, has much more lived experience of this and much more expertise than I do. So I will leave it to them. I think there's a couple of conceptual challenges when it comes to children and litigators litigating children and future generations' rights. I'm now skipping over to that again. First of all, where do children end and future generations begin? There's a huge issue around definition, both in international law and in domestic constitutional law. You spend a lot of time, if you're making an age or age discrimination case or a birth cohort discrimination case, are you talking about a generation? Are children in the here and now a future generation, an already born one? Are they a current generation, and unborn generations and future generations only means unborn children who are not yet born. So it's complex and it's not clear, and you have to work it out through litigation, because courts won't let you win if you can't say who's exercising the rights and what that means in practice. Okay. The second thing is it's challenging. You cannot assume that the interests of existing children or children as future adults and the interests of not yet existing future generations will necessarily be consistent. And some of this is because we don't know what will happen with climate change and everything is indeterminate. But some of it is simply that some of the changes we have to make in the here and now will negatively impact on children on the here and now, but will be beneficial to future generations. So there's no point pretending that children and future generations' interests will necessarily always be the same. And finally, I think we need to think very carefully that when we're talking about these groups and how their rights should shape democratic decision-making, should children's rights shape democratic decision-making in a different way? And should they shape the court's approach in a different way to future generations' rights? And that's something I'm working on, but actually it's a huge question. And again, we cannot assume they're exactly the same. So I'm going to leave it there. And I'm sorry for speaking for so long, but hopefully that set things out a little bit and others can piggyback off it a little bit. Thank you very much.
Thank you, Dr. Nolan, for the brilliant and very interesting presentation. And before giving the floor to Dr. Fresson, I would like to invite you to submit questions to the speakers through the Q&A session. At the end of both panels, we will have some minutes, hopefully, to address some of them. So, Dr. Fresson, it's a pleasure to hear you again. The floor is yours.
Thank you so much, Valeriana. I'm gonna try to share my screen. The host has to allow me to do that.
I think that Marina can do that.
While I wait for that, here. Oh my. Just a second. It's always, as Professor Nolan said, always a challenge.
I'm just going to put a couple of resources into the chat, if that's okay. Just before you speak, Caroline, if that's okay. Oh, you're ready. Great.
Okay. So, do you see my screen?
Yeah. Mm-hmm.
Great. So first of all, I'd like to introduce myself. My name is Caroline Halston. I am a jurist. I have a master and PhD from the University of São Paulo, and I'm a researcher in the climate crisis, and I am an Amazonian. I want to thank Valeriana, Lisa, and Emma, and others for the organization of this panel. I would also like to acknowledge that I'm in a company of very qualified people. So thank you everyone in the panel for being here. And I'm going to divide my presentation into three parts. So the first part, I'm going to talk about climate justice and its impacts, and in the second, some of the conflicts that exist, and in the third, I will bring a case that is happening here in Brazil, tackling with intergenerational rights. So first of all, I'd like to bring attention to the topic of climate justice and its impacts within the scope of intergenerational rights and children's rights. As Professor Nolan said, they're not necessarily the same thing, and we can pretend they are. But here I'm going to address them as a package. So the first contact that I had with these issues, I was lucky enough to be able to help to co-coordinate the Brazilian edition of the Mary Robinson Climate Justice case book. And here we see that we can see even back then that there were the manifestation of drastic effects of climate change. And it became clear that human rights are threatened and are regarding the impacts generated on health, food, and the instability of accommodation and infrastructure, mainly in coastal regions, triggering the disappearance of local traditions and cultures, and among other factors, and threatening the life society, especially the most vulnerable. And here we're talking about women, minorities, and children. So it's true that human rights are inseparable. So you have political and civil rights, and social, economic, and cultural rights are divided, but just in terms of in terms of didactics, not in reality. In reality, they are all connected. They are all intertwined. So what we have here is that the climate crisis is the biggest impact it has the biggest systemic threat to human rights. And in that, we have a tendency of seeing exacerbated effects in children and in the future generations as the climate crisis deepens and it becomes worse. On the screen, you see some examples of what we have to expect for Latin America in the next few years, according to the sixth assessment report of the Intergovernmental Panel on Climate Change. So what I wanted to highlight is that the relationship between environmental conditions, between the environmental conditions and intergenerational rights has to do with the broader objective of justice, and is conceptualized in maintaining basic needs and the possibility of functioning for both the individual and the community. So environmental justice, in this sense, it's built on the foundations of climate justice, which was a movement that started in the 80s, largely in the US. It had to do with the issues of burdens and benefits being allocated into minority communities. And today we see that overflowing to broadening that scope and harness and just, I'm sorry, I forget the word, broadening the scope and reaching other types of conflicts, not just distributional ones, but you have intergenerational conflicts, we have procedural conflicts, and you have and you have that with one similarity, which is that the most vulnerable, and according to the AR6, women, children, indigenous communities, and minority communities are the ones that are most vulnerable to the climate crisis, are disproportionately impacted, as Elisa said in the beginning of this presentation. So what I would like to say is that in Brazil, but also in Latin America, you have a slightly different scope for emissions. Here you have emissions that are largely on land use and occupation. And then that is relevant because you're going to see situations of climate injustice affecting children very differently in terms of urban children and rural children. And you're going to see that the the large variety of conflicts are going to happen also in the rural area. So here we're going to see the different dimensions of climate justice, and I'm not going to go into all of them specifically, but just wanted to highlight here the aspects that are pertinent to the rights of children and future generations. In terms of procedural justice means the fair, equitable, and transparent of procedures that already exist. But here, what we wanted to add is that it's important to be inclusive in those procedures. So you need to be, for that dimension to fully realize, you need to open up to other groups that are not necessarily represented in those scopes, in those places, and namely children. You have distributive dimension of climate justice, which is also going to, as I said, affect differently children or future generations that are born in the country and in urban areas. You have restorative justice, which means that you have the acknowledgement of a wrongdoing or the acknowledgement of a historical process that leads to the deepening of vulnerable positions that we put these groups, especially when we are talking here about minorities, children, women, as in the communities that I have already said. And what I wanted to highlight here is the question of intergenerational. And here, the dimension of intergenerational climate justice, it's linked to the Brundtland Report, which defines sustainable development as the ability to present for the present generation to meet its needs without compromising the future generations' needs. And regarding to that, you have attempts in Wales, Israel, Hungary, Finland, and Chile to indirectly insert future generations and children's needs into the decision-making process. So it's important for us to think about some arrangements, to think about what would those future generations rights, and how do we defend those future generation rights in the concepts of the instruments that we already have today. Because it is only by looking at this problem with seriousness and by trying to at least mitigate some of that gap that we are going to be able to tackle those questions more in depth. So I wanted to here state that we have, so I wanted here to state the different dimensions of climate justice, but also how climate justice impacts different ways that we tackle the climate crisis. We have climate justice that is connected to adaptation, which is the most common that we say, that we hear about, so resilience of communities, cities, withstanding extreme weather effects of greater frequency and severity. But we also have, and here we can see how children would be greatly impacted by that. There's also climate justice and mitigation when we're dealing with the adverse effects of some of GHG's emissions reduction solutions that deepen or create new situations of inequality between populations, and when we bet on one type of a solution of nuclear power, for example, we are just postponing, we're just burdening the next generation of with that decision. We're putting off the problem so the next generation will have to deal with it. Also, I wanted to say that we need to focus also in a context of climate justice on creating the conditions, on realizing the conditions, and realizing more than the conditions, processes that led to the climate crisis. And we need to prepare, especially in allocating prevention costs and the transferring of technology from the global north to the global south. With that said, I'm bringing here a case of that is happening here in Brazil, which was led by the Brazilian chapter for the Brazilian associated organization with Parents for Future, which is Famílias pelo Clima, which is an association of parents or uncles or relatives of children, and that they're advocating in their defense. In terms of, in the Brazilian jurisdiction, children do not have power to advocate. So we do need the parents to step up and advocate for them based on legal instruments that protect the children's rights. So what we have here is the Incentivaldo case, which is an air quality case. In 2009, there was a program on the government based on the government of São Paulo, which gave incentives to the automobilistic, to the car industry here for the production of cars. But it didn't have any safeguards. It didn't contain any limitations to the amounts of GHG pollutions that those cars could provide. So it was essentially a policy that perpetuated a deep dependency on fossil fuels and a deep dependency, not dependency, deep consequences of emitting more GHG gases. So what happened is that this group of parents issued a complaint, a civil complaint, to stop this policy in the names of their children. And you have here a rights-based argument, and you have what is interesting about the argumentation and how this case was built is that there are a broad range of arguments, and intergenerational argument is one of them, but it was what drove media attention more profoundly, is what the courts gave more attention. And so what we found here is that there is a really strong case when you are trying when you're trying a case based on children's rights, rather than just based on the rights for the protection of the environment, which is also a constitutional right. And in this case, there was a myriad of conditions that helped this policy die down, but one of those pieces was this litigation, which was highly publicized, highly debated, and issued and perceived as a success, because it supported other initiatives and at the end prevented this policy from going forward. So what I wanted to bring to you here is just one last consideration, is that we have had generations of environmental defenders that came before us, and they struggled, they gave their lives and trying to build a better future for their children. We are now the generation that is burdened with the current climate crisis, and how the decisions that we make today are going to shape the conditions of what our children are going to live in the next few years. And again, we're not talking about in 50 years, we're talking about in 5 years or 10 years. And as a person that lives in Latin America, that lives in the Amazon, that is going through an enormous heat wave right now, that temperatures are going to skyrocket over the weekend, it helps, I can't help but to think about what is the future. I'm sorry, we have to go. I have to finish.
Apologizing a lot. We are running out of time.
Sorry. I'm sorry. I'm just finishing. What is the future that we want to live for? That we want to leave for our children? That its decision is up to us right now. So I just wanted to finish with that. Thank you so much for the opportunity, everyone.
Thank you, Caroline, for your presentation, your insightful words. It was really interesting to hear about climate justice from your perspective. And now I'm delighted to invite Dr. Rosen Dai to his speech. I should just highlight that our speaker is facing some connecting issues. So he'll try to present without the camera to improve the Wi-Fi connection. And I would just ask to try to keep under the 8 minutes that we asked all the speakers. Okay, the floor is yours.
Thank you so much, Elisa. My name is Rongezai from the Northwest University in South Africa. I'm glad to be here, and I want to begin by thanking the organizers for convening this important engagement. This is, I'll switch off my video as I'm going to show my my screen. Thank you. My presentation, confines of the limited time, is going to offer
Sorry, I don't hear you.
The audio is breaking a bit.
Can I proceed?
Yeah, now I can hear you. Let's try again.
Yes, I can try. My presentation is focusing on children's rights and climate change in Africa.
Okay, I don't.
I will stop sharing, possibly to allow the next speaker to proceed, and then maybe I can try after the next speaker for the sake of time.
That would be great. Thank you very much.
I think that without the slides, we can hear just fine. If you want to try again.
Yes, so let me try one more time. My presentation is focusing on children's rights and climate change. That you're hearing me?
Not really. It's the connection is a bit unstable. Maybe we can try later.
Yes, that's fine. We get the next speaker.
Okay, so now I would like to invite Tabitha to as our next speaker. Please, the floor is yours.
Thank you so much for this chance and this opportunity. I'm really excited about it, and hopefully I can be heard clearly to that extent. Can I be heard?
Yes.
Okay, okay. So
Better now.
okay. So I'd like to share my screen. Yes, thank you. So today the topic of today is basically on intergenerational equity and vis-a-vis human rights and climate justice. And essentially, my work will be to look at it from the youth perspective, because I am a youth and I am a young lawyer and from Africa. So first of all, we have to look at what intergenerational equity is, and it has been expounded very well, and I can't really extend more on the same, but just to put more light on the same, intergenerational equity essentially is where this principle asserts that we must make decisions today that do not compromise the rights and well-being of future generations. This is to mean that what we make, or rather the decisions and actions that are made today, are going to affect our generations, our future generations. And the question then becomes, what are these effects going to be? Are they going to be positive, or are they going to be negative in nature? And essentially, this principle is so essential that it is part of customary international law and has always been expounded whenever SDG is concerned, because it is essential that we have to look at every single generation, the past, the present, and the future. And this is especially with regards to climate change. And of course, this is interrelated with human rights, because human rights are going to, or rather human rights affect people differently. And how the past generation is facing it might not be the exact same way that we are facing these challenges. Secondly, is that we have to look at the inherited responsibility of these actions that have taken place that have had or rather have had a bad effect towards the present generation. Now, we have to consider the fact that my generation has actually inherited a lot of consequences of past environmental degradation and the responsibility to mitigate the impacts of climate change. That is to mean that we have a lot, or rather we have a very heavy burden that we are currently facing and carrying because of the past mistakes that have been made. However, that does not mean that we are supposed to proceed with the actions that were detrimental to our environment and not consider how these effects were going to take place, especially to our future generations. And we also have to consider that this is interrelated to human rights. This is to mean that all these effects have to threaten our right to life, our right to health, our right to food, and our right to a clean environment. And these are fundamental rights that each and every human being espouses. So this essentially shows that we are fighting for our right to live in a world that is safe, healthy, and sustainable. And the only way that that can be done is that we take care of what we have now, and we ensure that we have put in mitigation factors that will ensure that our actions will not be detrimental to our future generations, as well as fix the mistakes that have been done by our past generations. Now, another issue is that we as youths are change agents. We have a very unique role to play in this fight for climate justice. We also have to consider that the youths are the majority on this earth. However, the sad truth is that we are rarely put on the decision-making table, such that we are adversely affected by all this climate change and every other aspect of human rights violations and every other thing that happens. And yet we do not have a space on the decision-making process. They make decisions about us without us. And that in itself is detrimental in nature. And so I would recommend that we as youths should always be part of the process, part of the decision-making process. And this is with regards to shaping climate policies and essentially just making decisions as a whole, us together as the as a present generation and the past generations. When we come together to make these changes, then there is effectiveness in the same. Another essential element is that there have been a lot of youth-led movements that are currently taking place. Now, there are very many youth activists and organizations that are driving towards climate action. Personally, I am in charge of several organizations that seek to have different objectives, but the major objective is that we are conserving our environment. And this include fossil, or rather divestment from fossil fuels, pushing for climate education, and holding governments and corporations accountable for their actions. Now, in the same vein, I think it is a good thing that as we have it, youths have been involved in one way or another in these processes, and that is to mean, for example, Yongo is part of the COP28. And normally we have the conference of youths before we have the conference of parties. And that is an essential drive that had to take place that is having a lot of implementations. Secondly, we also have the MGCY, which is working towards representing the global youths in the UN and especially the UNEP. And that is exactly why whenever we have UNEA, and we're going to have UNEA 6 next year, we also have the Youth Environmental Assembly preceding the UNEA itself, such that youths from all over the world come together and we put our minds together to find out what we can do as youths and as this generation to conserve our environment. And we ensure that we hold governments and corporations accountable for their actions. And of course, we take these measures through to the UNEA such that all these corporations and all these governments get to hear our voices. Now, to the implementation of our voices, that's another matter altogether. Something else that is very important is with regards to educational initiatives. We believe that climate education is essential for empowering future generations to address climate challenges. Now, you cannot be able to actively advocate for climate action if the people that you're advocating to do not understand the urgency and complexity of climate issues. That simply does not happen. And so climate education is very essential. And that is exactly why I would commend IUCN and YAA for holding this webinar. And such webinars really do come along to help us to understand the intricacies of climate issues. Something else is that it is essential to have intergenerational dialogue. Now, this is to mean that if we were to have every generation put on the same table, such that we think as one, we act as one, and we do everything as one, then that coherency will come to bring a lot of massive changes because we are working as one. After all, unity is strength. And so we recognize that solutions to climate changes require collective effort, and intergenerational partnership is vital. Something else is legal action. Now, as a young lawyer in Kenya, I can actually advocate for this. Sometimes the only solution that you can have is when you turn to the legal system to be of help. And this is especially to hold governments accountable and other corporations accountable for their climate policies. A good example in Kenya, and a case that I was part of, is the Changamwe case. Now, in this case, there was lead poisoning that was taking place as a result of a corporation that had its industries pouring its toxic chemicals into the rivers and the wells that were being used by the communities they're in. As a result of this kind of lead poisoning, it led to a lot of health complications. And we took this matter to court. And eventually, and of course, it is good news that we eventually got a compensation of 1.3 billion to these communities that were so heavily affected, and especially to the young nation. Because you can imagine 90% of these people who are affected were children and youths. And unfortunately, for the kind of poisoning that took place, they simply could not recover from that kind of effect. So these kind of situations, unfortunately, might take place. However, legal action is also very essential to ensure that these governments and these corporations that are degrading our environment are held accountable by our courts. Lastly, is with regards to intersectionality. Now, what I mean by this is that we have to recognize that climate change affects different people in different manners. That is, it affects marginalized communities, especially in different ways, such that these indigenous communities or marginalized communities include the youth, the disabled, the indigenous communities and such. Sometimes they do not have the same voice that the rest of the population does. And what essentially should happen is that these inequalities should not occur, such that we should have justice occurring for each and every person. Let them have the same space. Let them have the same seats on the decision-making tables. Let us acknowledge that they exist. Let us know that they also have their own diverse issues that are different from everybody else, such that we have to acknowledge as well that global South countries essentially face the challenges that are very different from the global North. And that is simply a fact. And when we take these things or these issues into consideration, then that means that we are able to come up with a sustainable solutions to these issues, such that we all...
We are running out of time. We would like to ask you to conclude when possible. I'm so sorry.
Yeah, it's okay. I completely understand. So simply to finish this whole presentation is that intergenerational equity is important, but for it to occur, certain things have to happen, as I have just stated. So I hope that you have enjoyed and you have learned something. Thank you so much.
Thank you so much, Tabitha. It's not easy for who is moderating to ask everyone to keep within the 8 minutes. In any case, I would like to invite Professor Rosendijk again, because maybe now he managed to solve the connection issue. So it will be our pleasure to hear from you. Please trying to keep within the 8 minutes. The floor is yours.
Yes. Thank you so much. I will try to share my screen. However, the hostess disabled my screen sharing. If you can support with that. Thank you. Now it's possible for me to share. As I do the screen sharing, just the introductory remarks to highlight that my topic is centered on children's rights and climate change in Africa, intergenerational impacts and insights. And the introductory remarks also highlighted that I was an external expert in the working group of the African Committee of Experts on the Rights and Welfare of the Child. And I should highlight that my tenure expired in August 2023. In as much as I share some of my experiences, I don't speak on behalf of the committee. but I speak on my own behalf and using my own experiences. And my presentation is structured in such a way that it points out to the regionalization of law and policy on environment and climate change on the African continent, and then speaking to the climate change vicious cycle. And this I speak to the impacts and how it affects the current generation and future generation, and then do a bird's eye view in terms of how the African continent and their national constitutions tend to cover children's environmental rights within the broader context of the right to an healthy environment. And then I will jump to opportunities and barriers and close my presentation. In terms of the African Union regional legal framework, it is important to highlight that the African Charter on Human and People's Rights, which is the foundational human rights charter on the continent, has a provision that speaks to the general satisfactory environment that favors the development of the African peoples. And this provision is quite broad, and scholars have also criticized that in its being too general, it does not then tend to cover properly the interests and the rights of children within the context of climate change and the environment. And an interesting observation is that the protocol on which is on the rights of women in Africa, defines women to include girls, and it has explicit rights that points out to a healthy and sustainable environment. And this speaks also to their inclusion in planning and management and the preservation of the environment and sustainable use of resources. Scholars then argue for the need to be quite inclusive and adopt an approach that ensures that the rights and the interests of girls within environmental management and climate change are incorporated when states are implementing the Maputo Protocol, as they call it. The African Charter on the Rights and Welfare of the Child is one of the excellent instruments that we have on the African continent. It covers all the unique rights of children on the continent, and it is the first regional or continental instrument that covers children's rights. It was adopted in 1990. It has one right that is not explicit to climate change or the environment, but one of the right, which is the right to education, speaks to education being directed to the development and the respect of the environment and natural resources, which the committee has emphasized the need to interpret broadly within national context. And because there is no explicit right to climate change within the Charter, the African Committee of Experts is then, in terms of the mandate in the Charter, come up with special mechanisms. And one of the special mechanisms is the Working Group on Children's Rights and Climate Change. And it's undertaking its first continental study, looking into all the 54 African countries and how climate change is impacting children on a higher scale at a regional level. Interestingly, the African Convention on the Protection, which they call the Maputo Protocol, includes climate change at a regional level, and this speaking to internally displaced persons and the need for states to take measures to protect people in Africa, including children. And the African Union Climate Change and Resilient Development Strategy and Action Plan is one of the new policy and instrument on the continent. And this is critical because it provides new guidance on the continent. And I will jump to speak to the vicious cycle. And here, there's a plethora of research that is speaking to the impacts of climate change and giving the statistics, the numbers, and I don't want to labor you into getting into those details, but to highlight the interconnectedness and the vicious cycle on the impacts of climate change now and in the future. And one of the critical issues that I'll begin by is government debt. African governments are getting into debt, and this has critical consequences in terms of how then governments should ensure social protection for children. And one of these might be relating to issues around climate financing and to ensure that African continent is protected from the impacts of climate change. So it links to social protection and how children ultimately are deprived of their rights and social protection on the African continent. The other key factor is conflicts, and conflicts will be as a result. It could be of water insecurity and the challenges that are happening on the continent. We have seen this happening in the Sahel regions where there are conflicts because of droughts that are happening in Ethiopia, in Somalia, and these are conflict induced by climate change and its consequences, and it links to hunger, to natural disasters. And one critical point to highlight is violence against children and how families that are impacted by climate change, it could be unemployment of the family, it could be loss of a family member, results in the perpetration of violence against children in so many ways. And ultimately, I'll close by the health risks that are linked to climate change. And it could be asthma, it could be any form of sickness that is linked to climate change. And when I speak to health risks, we have had instances where in many African states, the health systems are not up to scratch, and they're not in a position to provide good health system and services to the general population, and speaking to children in particular. Allow me to then jump, after giving this broader African continental perspective, to highlight that in Africa, 42 of the 54 countries have constitutional environmental rights that are the environmental right that is expressly mentioned in their constitution. And what this does is then it helps children to then push for the protection of their right within the environmental context. And many of them have an express mention of future generations within the environmental right, which then gives also a constitutional standpoint for litigators and for those that are keeping governments to account to utilize. Fewer countries have climate change legislation, and there are more countries that are in the process of adopting climate change legislation. And I think it also links to what the previous speakers have spoken about in terms of litigation and how that can help children. And more countries have climate policies and action plans that are bound across the African continent. What could be something to note is that amongst many of the climate change legislation that we have on the continent, they don't specifically link to children, but broadly just cover issues around climate change and mitigation and adaptation. And then it takes a special eye to interpret these provisions within the context of protecting the rights and interest of children. And I will jump at this moment, and I'll get towards the close to speak about the opportunities and barriers that are on the continent, without getting into specific countries, but broadly on the continent, is that the African Union governance structure itself stands as a barrier because there is fragmentation in terms of policies across the African continent. And not only that, but the way in which the African Union Constitutive Charter speaks about the sovereignty of countries, it takes away the power to be persuasive and to push governments and to ensure that they are accountable. Another challenge is climate finance. And this is linked to a debate and a conversation that in the previous weeks we had a African Climate Summit, trying to push the conversation on how there could be climate finance on the continent. And in this conversation, children are in the margins, children are in the sidelines. They are not really on the agenda, on the top of the agenda on the continent. The third one is that there is limited space, audience, and influence. And I think it's in line with also the Lundi model on child participation that is on the continent in terms of how children can participate and really engage to influence decision-making in terms of climate action, climate finance, adaptation. The last challenge and the barrier that I can highlight now is the slowness in judicial processes on the continent. And an example that I may give is a case from Uganda, the Bambazi case against the Attorney General and the Environmental Management Body. It started in 2012. And we are in the 11th year. And as far as I've ascertained, that matter has not been concluded. It was initiated by children, and by now they are no longer children. But when it was initiated, they were suing on their behalf and on behalf of future generations. And nothing has been done to develop the jurisprudence. In terms of opportunities, as I close, I see that there is more opportunities to amplify the voices of children within climate and youth activism within the context of supporting child activism and youth activism on the continent. It is impressive to see that we have activists and young women across the continent pushing the agenda, but I think more needs to be done when one looks at climate activists in the global south compared to those in the global north. There's more that can be done to ensure that the voices of children and young people are heard in climate action. The second point in terms of opportunities is the localizations of solution to the city level. I have done a study that looks into climate change and climate action at city level, which shows that cities have the mandate and cities are in a position to work on issues around environmental waste management, air pollution, and these are critical issues that cities could then, using their powers and mandate, support children and also create more platforms for children to speak out and also for children to be heard. And linking to issues around cities, such a case that was brought before the CRC committee in Geneva had children that they were speaking that they are coming from cities and they demonstrated the impact within their cities at the local level. And lastly, there's an opportunity to capitalize on the African Union's Committee of Experts and the special mechanisms that it has to try and push the agenda and mainstreaming the rights and interests of children on the continent. I thank you for the opportunity. Over to you.
Thank you very much, Rogenzai. Thank you for your great presentation and the perspectives you brought to us. And now I would just like to invite everyone to please make your questions using the Q&A, because in the end of the second panel, we will address all the questions to the speakers. And now I'm delighted to finally give the floor to Emma from the Youth and Environment Europe, who will moderate our second panel on more practical issues and focused on public interest litigation. Emma, it's over to you.
Many thanks, Elisa, and many thanks to all the speakers of the first panel for the super interesting presentations. I am Emma. I am from Youth and Environment Europe, and I will moderate the second panel. So briefly about Youth and Environment Europe, YE is the largest European network of environmental youth organizations, which is reuniting 48 members from 26 countries. So since 2020, at YE, we run an environmental project called Legal Seeds, with the aim of empowering young people to use the law in their political advocacy. This year, our focus is to support young people in accessing justice and in engaging in climate litigation and in strengthening youth voice in key climate policies. So I have the pleasure to introduce the second panel, which is composed of 3 young advocates involved in youth organizations, currently following legal campaigns and climate lawsuits. So the first speaker is Douglas Malmra, a board member of Aurora Mallet, who will introduce the Aurora Youth Organization. So Aurora's goal is to defend the statutory rights of children and young people to a good environment, life, health, and development. This is done by preparing and pursuing a legal process against the Swedish state for its inadequate and counterproductive climate policy. The second speaker will be Samira Ben Ali, Outreach and Engagement Coordinator of World Youth for Climate Justice, who will give an overview of the campaign to seek an advisory opinion from the International Court of Justice. And finally, we will have Alexandros Kasapis, a member of Youth and Environment Europe and one of the plaintiffs of the climate case Subeste and others versus Austria and 11 other states, who will present the Subeste lawsuit with a parallel to Duarte Agostinho. And I remind that Duarte Agostinho will be heard next week at the European Court of Justice. All of the 3 speakers will share their experiences and perspectives in climate litigation and campaigning. So with that said, I would like to give the floor to Douglas and for him to present.
Thank you. So fun to be here and listen to everyone talking. I am going to be underwhelming and I don't have a PowerPoint. I am sorry for that, but I will try my best to keep keep a red line going. And I'll start, well, what is going to happen in Sweden when it comes to climate change, and move on from there. So many public institutions themselves are stating that there will be a lot of negative effects in Sweden. We are going to see increased floods coming from increased rain. Just this year, a storm passed through the country and caused major damages, both to people and infrastructure and houses and everything. We also gonna have more frequently occurring heat waves, in line with most other countries. And I think 3 years ago we had a super hot summer, and 700 people, I think, were died in excess over the normal rate, attributed to then the heat. We also have the spread of ticks and other animals carrying parasitic diseases. We are going to see crop failure, heat waves, as I said before. Okay. And going from this, I am not a law student myself, but that might be a nice perspective then. This is going to cause a lot of harm to young people. Not only the physical damage that I talked about, which the youth will be disproportionately affected by, because we are people who are going to live through these things, not the older generations to the same extent. But also the psychological harm from knowing that this is going to happen, and knowing that politicians are ignoring what they can do, and avoiding responsibility, avoiding action. And yeah, we've claimed that this is in violation of our human rights, according to the European Convention of European or Human Rights. Yes, several articles. We have the right to life, which is threatened. We have the right to not experience torture or inhuman or other types of treatment, which it's much more likely to happen as climate change gets worse. And the same for protection for private life and family life, as well as to property, to the places you live and the places you are dependent on. And also, since this is going to affect a specific age group, which are those, well, the younger you are, the more of these effects you're going to actually have to face, then we also claim that it is in violation of the 14th article, which is against discrimination, basically. Yes. And we'd also claim that this doesn't have to be materialized yet, but needs to be, like, you can show that it is a very predictable risk of these things getting worse and worse as climate change goes on. And yeah, and to attack the Swedish government, or like the actual reasons for why it's not fulfilling its obligation to act. We state that Sweden's climate goals, which we're not on the track of reaching at all, and the new government is making things even worse by basically subsidizing fuel. Well, the climate goals we have do not account for even half of our emissions, but ignores emissions from the burning of biomass, which comes from the continuity forests of Sweden that have been cut down extremely fast for the past 70 years, as our emissions in fossil fuels have decreased. They have simply been replaced by biomass, which is not going to recover during the time we need. And they're also just replaced, or they are logged through clear cutting huge amounts of forest and destroying ecosystems as well. And they are also ignoring the imported emissions that come from us consuming things that are manufactured in other countries. So we demand also that it needs to be recognized that our position in Sweden as top of a global and unequal supply chain system needs to be recognized and accounted for in while actually designing the targets. So we demand that the courts recognize that Sweden is breaking these laws, because it is by not acting and not even accounting for emissions, they are severely avoiding responsibility for justice considerations taken like that we've already agreed on in the Paris Constitution and other international agreements, plus that it puts us at risk as well, the young kids. That was, they haven't even like figured out a plan to calculate what could be our fair share of emission reductions, and similarly. So yes, we also included some projections of how fast we would actually need to decrease our emissions, taking account justice considerations in the Paris agreements and other international environmental cases or environmental laws. And moving on to the role of the youth in the case, it is quite complicated as an organization. We are comprised of youth, basically, which we defined as younger than 35, which seems high, but many of our members who are also environmental student lawyers, or in training at least, are slightly older. Yes. So we are the ones like representing the organization, but in the lawsuit, we also made use of a special Swedish type of case called like a group case. So we also have 360 something youth who are like taking part of the case. We are like, speaking for them as well. And then, yes, the board is in constant discussion with like the law students who like in cooperation with our actual lawyer is constructing the arguments. So we also have like a say in what we think is important, and like how law can be made to affect what our feelings and how we feel like the government is mistreating everything. That was very strangely put. But yes, so we have the law students and the young people in the board. We all also like constantly involving in having like bi-weekly plenaries and discussions, and we in our working groups around campaigning around the case as well. It is like anyone who can join things. It is just like the actual law work is prohibited to like a smaller group because it's much more secretive. At least, but the youth do the campaigning. We drive the actual like moral questions we want to see, and to explore some of the challenges we've had. Well, partly this is attacking basically greenwashing in the Swedish climate accounting, and this has become very institutionalized, and is part of what Sweden has built their reputation on, by actually not accounting for the emissions, but moving them to other posts. And that makes us not just questioning a specific policy, but like the consensus that the Swedish climate policy has been built on for a long time. It can also be acknowledged that, cutting down the forests also violates indigenous rights, even though that is not a part of the specific lawsuit. Am I on time? Sort of.
Yes, you can reach the conclusions. So, but you're in time until this.
Okay, thank you. I think the most resistance we faced is, one, it's very expensive to drive climate cases in Sweden. We also don't want to accept money from most people, so we had a lot of success in crowdfunding and regular people contributing to fund the actual lawyer costs and stuff. I think the most common argument, which we've heard from both industry representatives, editorial newspapers, and equally the government replying to our answer, is like it's a non-democratic way of forcing politics through courts. Well, that is not what we demand. We do not demand specific policies, but just that we want the court to state that the state has a positive obligation to actually undertake certain measures. How exactly they do this is not up to us to decide. Yes, that was it for me. Thank you.
Thank you very much, Douglas, for presenting the Aurora Mallet initiative and your experience with that. I remind everyone, if you have questions, to leave them in the chat, in the Q&A session, I will say, and we will go through them later on. Now I will pass the floor to the second panelist, Samira Ben Ali, who is from World Youth for Climate Justice, and who will give an overview of the campaign, which is led by youth to seek an advisory opinion from the International Court of Justice as one of the ways of addressing the inequity arising from the climate crisis. I just heard that probably you have some internet issues as well at the moment. So please let me know if you'll be able to speak. Otherwise, I will suggest to move to Alex, and we will go back to Samira in a bit. It seems that these days internet is not going up. Okay, so what I can suggest then is to move to the third panelist. Alex, are you with us?
Hello there. Yeah, I am here, but I just see that
Okay.
Samira sent a message in the chat that they will be able to speak.
Okay, I don't. Okay, Samira, then I will pass the floor to you. Perfect. Thank you so much, Alex, as well. Samira, the floor.
Thank you. Can you hear me clearly? Thank you very much. Thank you for the invitation, Emma, Marina, and Elisa, and all the other people who organized this. Sorry, I'm really sorry about the internet connection issue. I will try to speak as fast as I can until it starts to accept again. My name is Samira Ben Ali. I'm French, and I'm part of the World Youth for Climate Justice, which is a youth NGO that is mainly focusing on climate change and human rights through a process that is called advisory opinions. Advisory opinions are basically legal questions that are being asked to a court or a tribunal generally on a matter that we consider that we do not have the answer to. And the World Youth for Climate Justice is an umbrella organization in partnership with Pacific Island students fighting climate change. So when I was invited here today, I was asked to talk about the campaign and how this youth movement that has been born from a really small stage was able to become more international, and how it was able to be like a global campaign, and stress how youth movement can really have an impact on a large scale when it concerns environmental law, and in particular international environmental law. So to be able to speak about that, I'll go at the beginning of WYCG. That was not at first WYCG. At first, it was only the 27 Pacific Island students who were students of international law and who were seeing the changes happening in their different islands and considering how they could do to try to make sure that those changes that are happening because of climate change, negative changes, could be stopped. They tried to look at law, international environmental law, and tools that have been made, that have been put in place to try to defend our cause. And they have been really inspired by Paolo, who in 2011, the state of Paolo tried to take climate change to the International Court of Justice. They were seeking clarification on the obligation of states to cut greenhouse gases to avoid transboundary harm. This first attempt by Paolo was unfortunately ineffective, but from that, those 27 lawyers were able to build a campaign that was really inspired by this first one, and they added to it the notion of human rights, how the effects of climate change were going to impact our human rights and what were the state's obligations to try to limit those effects. So they also understood really early on that this campaign could not be contained only on Pacific Islands. It needed to have a global reach because they needed for this campaign to go to the UN and have a resolution voted. And this resolution had to at least have a majority of votes from all the UN countries for it to pass and go to the ICJ and for the advisory opinion to happen. That's how they were able to reach out to different youth on several continents during events such as COPs and build a more global movement. And this is how WYCG, World Youth for Climate Justice, was born, and it became a global movement. From that, we have been able to build different fronts on different continents, get in contact with stakeholders of their own countries, and try to defend this idea of an advisory opinion on human rights and climate change. Yes.
Thank you, Samira. We have some problems with the audio, so if you'll be able to fix it, because we cannot really hear just the last 5 seconds. Thank you very much.
I don't know. Can you hear it better now?
Maybe what I suggest is to close your camera just to be sure. Thank you so much.
Okay. I'm gonna try maybe to speak like this without the camera a little bit closer. Can you hear me better now?
Actually, it's
what we can do is like maybe you can close speak very closely to the microphone and try to reach the conclusions. Because
can you hear me
cannot,
better?
Not really. I think that you can say a couple of sentences maybe to finish the speech, because also if you're close, I cannot hear you properly, honestly. So yeah. Yeah, like for example, now we cannot hear you, so apologies for like cutting like this. But the only solution I can find is to.
Okay, like this. Can you hear me a little bit better? No.
It's a bit better. If you reach some conclusions of the speech, then we can move to the other speaker, because I don't.
I will try
think
to.
it will... I'm sorry, Samira. I think we have to move on because we cannot hear you. We cannot hear you. So yeah, sorry
no
so much. You can send the presentation or the text via email, and we will disseminate to those who are interested. And thank you again. I will now pass the floor to our last panelist of the day, since we reached the conclusions. So it's my pleasure to introduce Alex Kassapis, from Youth and Environment Europe, but also a plaintiff of the Subeste and others versus Austria and 11 other states, who will give a presentation about the topic. Alex, can you hear me?
Yes.
Okay. Are you able to present? Thank you so much.
Yes. So I'm just presenting. Can you see my slides?
Yes.
Yes.
Okay, that's perfect. Okay, sorry. You will hear my voice, but you will not see me, as it seems like my camera also has some problems. It's not been the luckiest day with technical issues, but basically, yeah, I would like to express a big thank you to the organizers and as well as to everyone who has spoken so far. Thank you very much for all these very interesting issues, and I'm very happy to be closing it off for today with an overview of young people in the climate movement, a reference to the Duarte Agostinho case that we're going to have the hearing of next week in Strasbourg, and a connection to a case to which I am a plaintiff called Subeste et al., also in the European Court of Human Rights. So to begin with, I would like to say that I'm much grateful to an article I stumbled upon earlier in the week, which was titled Youth Movements, Intergenerational Justice and Climate Litigation in the Deep Time Context of the Anthropocene by Kodze and Knapp, which I will also share in the chat box for those who are interested. And I would like to start with sharing some general information, starting with what Tabitha also highlighted earlier, which basically had to do that young people are not only the least responsible for global emissions, but they are also the least able to influence policy efforts that could avert the worst impacts of climate change. And although youth movements are not a new phenomenon, there is something very new that we are seeing in the context of the climate movement, that is that activists are often very young children and comparatively younger than people that have taken place in past youth movements. And it's very interesting to see how young people are very empowered by thinking that I will use the term we now, counting also myself as a young person, basically are advocating and are getting empowered from thinking that we represent the future generations. And this is really starting to change from thinking that the future generations are simply people who are just absent and distant, just unborn generations that we don't know exactly what is going to happen to them. But rather than that, we now have the scientific clarity to know that they will suffer not really that far into the future, but rather that we are the ones who are suffering now, and it is going to get worse and worse. But even though we know this and we have these positive developments in politics, we still know that when it comes to even large climate instruments like the UNFCCC or the SDGs, it could be described that youth participation has been like sort of a mixed bag. And there have been basically, sadly, these researchers that indicate how the short-termism that really affects current democratic regimes and how basically treat young people as not really legitimate political subjects. Instead of considering us as human beings, we are rather perceived as human becomings in the Western society. And although we are becoming increasingly empowered as young people, we still have to face political actors and elected politicians who will govern for the present, will govern for the next 4 years, and will not govern for climate futures or any future generations. So as elected representatives are quite prone to ignore our demands and not use their political responsibility for future generations. And it could be argued that businesses are doing the same with throwing the blame on shareholders of their companies. And this is the very sad reality that we have to face. But still, happily, there is growth in youth-led climate litigation cases. Some are successful, others are still to a large extent being dismissed by courts. And there are, of course, the barriers of how young people have a lack of awareness of available legal remedies and processes, and there are also significant financial burdens. And this is exactly what our project in YEE is also focusing on increasing the awareness of young people on how to bring claims, how to use the law in order to claim the rights that we have compared to our worsening environmental condition. And we really hope that youth-led climate litigation will increase as courts and youth litigants are becoming more and more familiar with how to navigate all the complexities that the law is presenting. And having now said this introduction, I would like to refer to the case of Duarte Agostinho. So we see the images of the 6 plaintiffs who are behind the case. It's also very interesting. We always read all these case names and about the proceedings, but it's, I think, very important to also know the face behind a claim. And the 6 young people aged from 11 to 24 at the time that the lawsuit happened, basically started the claim following forest fires that destroyed their home area, killed 66 people in Portugal. And using a lot of crowdfunding, similar to what we heard also from Douglas before, from Aurora. And they actually managed to gain over £100,000, and now they are seeking a binding ruling from judges against a very big number of countries. And if I've read correctly, it's going to be the claim which is directed against the most countries that will be heard, basically in the European Court of Human Rights. These are all 27 members of the EU and Norway, Russia, Switzerland, the UK, and Turkey. And now let's look into what are these kids or young people claiming. Basically, they are based on different articles of the European Convention of Human Rights, starting from the right to life, Article 2, and the right not to be subject to inhuman or degrading treatment, covered by Article 3, Article 8 on the right to private life, and very, very interestingly, Article 14 on the right to non-discrimination, because as the claimants of such a young age, climate change will have higher impacts on their lives compared to adults and younger people, which therefore bring up a clause of discrimination. It's very interesting also how different European states have replied to these claims that have been made. And I would like to refer to my home country to basically indicate the very sad ignorance shown by the government when it comes to that. My home country being Greece, we have had detrimental forest fires as well in the past summer. And we even had our Minister for Climate Change saying, literally quoting him now, that the climate crisis that brought us this unprecedented heat wave is here. It's not a theory, it's our actual experience. But at the same time, when the Greek government was called to reply on the claims brought by the young people in Duarte Agostinho, the government defense said that an absolute cause and effect relationship between climate change and the effect on human health cannot be established. There is great uncertainty about whether the final mortality balance will be positive or negative. Yeah, just hearing this claim, I think you can understand for yourselves how cooperative it seems that governments such as the Greek government are in such cases. And it's very, very, very interesting and looked forward upon by us young climate activists to see what is going to happen next week. And also happy to know that representatives of YE are going to be present in the hearing, such as Emma as well. And it's also very interesting to see that the court's finding, basically in relation to one of each of these claims, will deduce the ability to challenge future climate harms in international dispute forums on the grounds of human rights violations in more cases. And such a case is the case that I have also brought with 4 fellow young members from European states, which is against the Energy Charter Treaty, a topic that has been quite unheard of, but that has had quite a prominent role now in the latest climate discourse, in the latest years, although it came quite late. So in this image, you can see myself being in the middle, the person wearing the glasses, and then Maya Subesta, whose surname also is in the name of the case, is the person who is on the most left, as you're seeing your computer screen right now. And basically, we are all victims of natural disasters that have to do with climate change. For me, it was forest fires, and my home outside Athens, Greece, was almost burned twice in the summer of 2020. And for Maya is from Saint-Martin, the French overseas territory, which was subject to a hurricane that completely destroyed her neighborhood. Similarly, the 3 other plaintiffs have also been victims of floods, and they are from Belgium, from Germany, and from Switzerland. So we are 5 people from 5 different countries, and we are basically making a claim that is quite tied to that of Duarte Agostinho, meaning that we are also based on Articles 2 and 8 of the European Convention of Human Rights. Basically, these articles, the right to life and the right to privacy, have to do also impose a positive obligation on states to basically protect these rights from environmental threats. So this claim will be answered from the cases that have to do with Duarte Agostinho. And similarly, if you're familiar with the cases of Carême and the Clima Señorinan cases, which are all being heard in the European Court of Human Rights this year. And for this reason, our case has been adjourned until we have basically heard back a judgment from these cases. Because what is going to be decided for these cases, how human rights are connected to climate change and climate inaction, is going to determine about, pretty much half the claim of our case as well. But the novelty in this case is the other half, which is that it is the first time that there is a human rights case which is being tied to an investment treaty, because the Energy Charter Treaty is an investment treaty. So you may ask then, how does an investment law affect human rights? And the case is that the Energy Charter Treaty is basically a treaty among many European states, as well as actually Central Asian countries and even Japan. And it basically protects foreign investment in energy supply by means of private arbitration. There have been over 150 claims under the Energy Charter Treaty, which have resulted into billions of euros going into fossil fuel companies. They basically protect the interests of all energy companies, but it has been recognized that fossil fuel companies could really take advantage of this treaty, and this could result into claims that would amount to more than 1 trillion euros to fossil fuel companies. This money is basically taxpayers' money that is to be gone to the fossil fuel companies if the private arbitration court determines that. So imagine when in a time of a climate crisis, if we have to award so much money going into who has been the polluter for all of these years. So basically, our case is based on many statements by different stakeholders, which indicate that governments in Europe and the 12 states that we are suing, so Austria and 11 other states, concerning all of the states where there have been also private arbitration procedures against. We are claiming that they have been made so hesitant to act on climate. So because of their membership in this treaty, if you know, the fossil fuel company is going to sue you for trying to shut them down, of course, you're going to have a delay in shutting down this company. Currently, the Netherlands is being sued by the German company RWE for over €1 billion. And a few years ago, the British oil company Rockhopper got awarded millions of euros from the Italian government when the Italian government attempted to shut down their offshore drilling. And this is a recurrent pattern, sadly, that fossil fuel companies are basically aiming to get all this money from the governments at a time when the government should probably take all the money that they have in order to redirect it into like the absolutely necessary energy transition. And yeah, so it is sort of a life insurance for fossil fuel investors, something that definitely has to be scrapped off. So all of us 5 young people have a victim status for the purposes of the European Convention of Human Rights, and that's why we could go to court. And we've been very lucky because we've been very supported by different actors, those being a whistleblower, Yamina Saheb, who revealed these different facts about how the Energy Charter Treaty has been awarding so much money to fossil fuel companies, to an NGO called the Veblen Institute, and to our lawyer, Clementine Baldon. And all together, they worked and they helped us to bring out our voices in order to instigate this lawsuit, which was made on the 21st of June, 2022. So we are very excitedly awaiting for the judgment of the Duarte Agostinho case, of the Carême, and also of the Clima Señorinan case, in order to see how our case would move on as well. But I'm very happy to share that after we filed this case, there was actually, it was really captured by the media and shared extensively. And it did lead to a lot of uproar and criticism, which I hope did result in different governments deciding to withdraw from the Energy Charter Treaty. And these include the Netherlands and Spain and Poland and France. So this also shows how even though the case has not even been heard yet, it has already had an impact that 5 young people took the law to their hands in order to bring this claim. Yeah, so this is about the Energy Charter Treaty and the case. I guess we don't have much more time, but yeah, happy to see any questions. So basically, yeah, I'd like to just move on to the next slide. So yeah, just to say thank you very much, and please feel free to contact me on my email if you have any questions. And yeah, thank you very much.
And thank you so much to you, Alex, for the presentation, and also for sharing you as well the experience with us. It's always very interesting to learn from direct experiences. I will now pass the floor back to Elisa for final remarks. And yeah.
Well, thank you, Emma. Thank also all of our panelists and speakers of the second panel. It was really interesting to hear from your perspective as well. And before moving to a very quick Q&A section, as we have mentioned some climate and environmental hazards during the previous speeches today, I would like to invite Ayman to say a few words about the earthquake that hit Morocco some weeks ago. Maybe Ayman, if you want to.
Thank you. Well, thank you very much. Very briefly, and of course, there's the earthquake that hit Morocco. There's also Storm Daniel that hit Libya. As a lot of the conversation, and first I want to commend all the panelists for the excellent presentations. And there was a focus on climate litigation, so of course, it'd be more connected to the second of those very unfortunate affairs, which is the Storm Daniel in Libya. I happen, however, to personally have lived the Morocco earthquake in this very room, actually. Fortunately, I didn't directly suffer from it, but that was not the case for many, including many children. And I wanted to make a connection to some of the provision as we discussed the Convention on the Right of the Child, particularly, of course, on Article 6 and 28, if I'm not mistaken, of course, the right to life when it comes to Article 6. But I wanted to also highlight Article 28 about education, because that's something that we tend to forget when we are hit with this kind of catastrophes, is how do you maintain this right of these children that are in the impacted area to education. And for example, in Morocco, of course, the first priority was to deal with and limit the human causalties. And now we are on the road to recovery, but also with a strong focus on education. And to give you some figures, more than 6,000 children in the area have been reallocated to different schools where they're not having risks of suffering from further impact again. Also, more than 150 tents were provided and adapted so that they can receive classes and lessons. And also, of course, bearing in mind the importance of mental health and well-being, because it's also important to keep that in mind. So yeah, that's what I wanted to contribute. I hope you found it of interest. Thank you very much.
Thank you very much, Ayman. Well, we just have one question in the Q&A box. It was sent by Sarah from Pakistan, and I'll just read the question. In the context of violation of rights of future generations, do you think there is any merit in the legal argument that by government failing to greenlight renewable energy projects as opposed to fossil fuels, if that is a violation of children's rights to life and to clean and healthy environment? So if anyone would like to address this question or just make a final statement, please go ahead. Anyone? So, well, we just like to thank you all for accepting our invitation and for the very interesting presentations. I think we can agree that it was very successful and we all learned a lot. So thank you very much. I would just like to give the floor back to Elisa so she can conclude the session. Thank you.
Oh, thank you, Valeriana. We are finishing now. Valeriana, Emma, and I would like to thank all the speakers who accepted our invitations, and also all of you from the audience who dedicated your time, your energy to be in this webinar with us. In the next few weeks, we hope that maybe we have a video with all the debate we had today. And also from the side of the Early Career Specialist Group, we expect to publish a policy brief with the main ideas we discussed today. So we'll let you know when this is ready. Thank you again and see you. Bye.